For years, this was the end of the journey, the final prize. After a decade of visa fees, stress and uncertainty, after finally securing indefinite leave to remain, the British passport was supposed to be a formality, a confirmation of your place in this country. That is no longer true. In 2025, the path to citizenship is not a final step. It is the final, most treacherous minefield. The Home Office has laid a series of hidden traps, a set of unwritten rules that can disqualify even the most deserving applicants at the very last moment. These are the secret citizenship bans, the ghosts in the machine designed to catch you out when your guard is down. Today we are going to expose the 5 critical citizenship bans that everyone who holds ILR or hopes to one day must understand. Your belief that ILR means you are safe is the most dangerous assumption you can make. Before we arm you with this vital knowledge, I need you to do something important. Share this video with every single person you know on a UK visa. This information is not just useful, it is essential for protecting a decade of hard work. Give it a thumbs up so that this warning can reach more people. To my returning subscribers, you know we go deeper than anyone else, and I thank you for your support. If you are new, subscribe now, because what we are about to discuss could be the difference between holding that passport and receiving a soul-crushing rejection letter. Let's begin with the most insidious trap of all, what I call the good character time bomb. Every citizenship application hinges on the applicant proving they are of good character. In the past, most people with ILR assumed they had already passed this test. After all, you cannot get settlement if you have a serious criminal record. But in 2025, the Home Office is treating the citizenship application as a full forensic review of your entire life in the UK, and they are using a much finer microscope. The time bomb is this: a minor issue from your past, something you thought was resolved and forgotten years ago, can be resurrected and used to deny you citizenship. We are not talking about serious crimes. We are talking about a fixed penalty notice for a driving offence from 7 years ago. A minor, unintentional tax discrepancy that you settled with HMRC 4 years before you even got ILR. A brief, accidental period of overstaying between visas that was rectified a decade ago. The Home Office's position now is that holding ILR does not wipe the slate clean. They will re-examine every single piece of data they have on you, and if they find anything that, in their opinion, demonstrates a lack of respect for the law, they can refuse you. It is a retroactive punishment. You are being judged today for a mistake you made yesterday, even if you are already forgiven for it. The good character requirement has been weaponized into a ticking time bomb placed at the very start of your immigration journey, set to detonate at the final hurdle. The second trap is the digital ghost and the travel ban. To gain citizenship, you must prove your residency in the UK, which includes sticking to strict limits on how many days you have spent outside the country. The rule is clear: no more than 450 days of absence in the 5 years before you apply, and crucially, no more than 90 days in the final 12-month period. This has become a brutal, non-negotiable ban. Going over by even a single day, perhaps because of a family emergency or a cancelled flight, will almost certainly lead to an automatic refusal. There is virtually no discretion. But the real trap here is the digital ghost. The Home Office no longer just relies on the stamps in your passport. They are building a complete digital picture of your life. They can access flight manifests, bank transaction data showing you using your card abroad, and even scrutinize your social media for posts that contradict your declared travel dates. If your digital footprint does not perfectly align with the dates you have provided, you will be flagged. If you cannot account for every single trip with perfect accuracy, you risk being accused of deception, which is an instant failure of the good character test. You are being haunted by your own digital ghost, and any inconsistency can destroy your application. You must be a perfect record keeper, because the system is designed to punish anything less than absolute perfection. Third, we have the financial inquisition. This goes far beyond simply being employed or financially stable. This is a deep, forensic dive into your entire financial history in the UK, and it is where many people are now being caught. The Home Office is cross-referencing data with HMRC, the tax authority, with unprecedented aggression. They are looking for skeletons in your financial closet. Did you do a small Cashingham job 5 years ago and forget to declare it? Did you make a small innocent error on a self-assessment tax return that you never even knew about? Were you ever a director of a company even for a short time, that was later found to have compliance issues, even if you had no part in it. This is an inquisition because the burden of proof is entirely on you to prove your financial purity over many years. Any discrepancy they find, no matter how small or unintentional, can be framed as dishonesty and tax evasion. It creates a presumption of guilt. Imagine a freelance IT consultant who 6 years ago received a £1,000 payment from an overseas client and mistakenly categorized it in a way that resulted in a £200 underpayment of tax. Even if they were never contacted by HMRC about it, the Home Office's data matching could flag this during the citizenship process, leading to a refusal on good character grounds. Your entire financial life is under scrutiny, and you are being held to a standard of perfection that few can confidently claim to meet. The fourth ban is perhaps the most frightening, the association ban. The good character requirement is not just about your actions, it is also about the company you keep. In 2025, this is being interpreted more broadly and more terrifyingly than ever before. You can be denied citizenship based on your association with individuals the Home Office deems to be of bad character. This is not just about being friends with convicted criminals. It can be far more tenuous. It could be a business partner who, years after you parted ways, was investigated for fraud. It could be a tenant in a property you rent out who is involved in illegal activity without your knowledge. The true danger here is that you can be judged on information you are not even aware of. The Home Office can use intelligence or evidence that is not disclosed to you, citing national security or confidentiality. You could be refused citizenship because of someone else's actions, and you may never be given a clear reason why. It creates a chilling effect, forcing you to question every personal and professional relationship you have. Your life's biggest achievement could be denied because of a person you barely knew, whose wrongdoing you had no part in. Finally, we have the future intentions ban. This is the most subjective and forward-looking trap. To become a citizen, you must declare that you intend for the UK to be your principal home for the future. In the past, this was largely taken at face value for someone with ILR. Now, the Home Office is actively looking for evidence to contradict your declared intention. They are looking for signs that you might be a citizen of convenience, someone who wants the passport for its travel benefits but plans to live elsewhere. What evidence are they looking for? Maintaining a large property portfolio or significant business interests in your country of origin can be a red flag. Having your spouse or children living primarily overseas is another. They are even scrutinizing social media. Have you posted online about your dream of retiring in the sunshine of your home country? Have you talked about plans to move to another country for work once you have the security of a British passport? This is a thought police ban. The Home Office is attempting to read your mind and judge your future plans. You are being denied a present realiteel citizenship based on their speculation about your future. It's a final cruel twist. After spending a decade proving your commitment to the UK, you can be denied for simply dreaming of a future that doesn't fit their narrow definition of permanent settlement. So there you have it. The 5 hidden bans. The time bomb in your past, the digital ghost of your travels, the financial inquisition, the danger of association, and the judgment of your future thoughts. Getting ILR is no longer the end of the marathon. It is the start of the final precarious sprint across a minefield. Your future in the UK depends on you understanding these traps. In 2025, the British government has slammed the doors shut. Not with a gentle click, but with a resounding, deafening boom. For entire groups of people, the well-trodden path to permanent settlement, known as indefinite leave to remain or ILR, and the coveted prize of British citizenship is now a dead end. This isn't a minor policy tweak. This is a revolution in British immigration. And if you, or someone you know, has plans to build a life in the UK, you need to stop everything and watch this. Because today, we are exposing the 5 groups of migrants who have been told no more UK citizenship. Alright, let's start with a group that might surprise you, but it's a crucial place to begin because it busts a huge myth. The first group facing a hard no are visitors to the UK. Now you might be thinking, well of course, you can't get citizenship on the tourist visa. And you'd be right. But you would be shocked at how many people believed in a loophole, a kind of backdoor route. The idea was simple. Come to the UK as a visitor, find some way to switch to a different visa, and start the clock on settlement. For years, this was a grey area. But in 2025, that grey area has been painted over in black and white. The UK Home Office has made it explicitly, unequivocally clear, a visit visa is for visiting. Period. The conditions are now so rigid that switching from a visitor visa to any long-term route, like a work or family visa, from within the UK is virtually impossible. Think of it like this. Your visitor visa is a ticket to a concert. You can enjoy the show, experience the atmosphere, but you can't use that ticket to get a job as a roadie or move in with the band. Once the show is over, you have to leave. Furthermore, with the expansion of the Electronic Travel Authorization, or ETA scheme, in 2025, even getting that initial entry ticket is becoming more formalised for many nationalities. The UK is tracking every entry and exit with a digital microscope. The message is crystal clear. If your intention is to stay, don't come as a visitor. That door isn't just closed, it's been bricked up and plastered over. For visitors hoping to find a way to stay, the path to ILR and citizenship doesn't exist. It never really did, but now the illusion has been shattered for good. Now we move into territory that is far more controversial. This is where the government has drawn a moral line in the sand. The next two groups are being locked out of citizenship, not because of their visa type, but because of how they arrived in the UK. We're talking about individuals who entered the UK illegally and individuals who made a dangerous journey. For decades, the path to British citizenship had a fundamental requirement. You had to be of good character. It's a deliberately vague term, but it generally meant things like paying your taxes and not having a serious criminal record. If you had entered the country illegally, say 15 or 20 years ago, but had since built a life, had a family and been a model resident, the Home Office could often overlook that initial transgression. It was seen as a past mistake on a long road to redemption. As of February 2025, that road to redemption has been closed. The good character guidance has been rewritten with steel and stone. The new rules state that anyone who entered the UK illegally will normally be refused British citizenship. The 10-year forgiveness period? Gone. It doesn't matter if it happened last year or in the last century. An illegal entry is now seen as a permanent stain on your record, one that disqualifies you from ever calling yourself a British citizen. And this leads directly to our third group, which is a specific focus of this new policy: those who made a dangerous journey. This is a direct response to the small boat crossings in the English Channel. The government has defined a dangerous journey to include methods like arriving on a small boat or being concealed in a lorry. Under the exact same good character rules, taking such a route is now a lifetime barrier to citizenship. Think about the implications. This directly targets many asylum seekers and refugees, people who, under international law, may have a legitimate claim for protection. The UK is still obligated by the Refugee Convention to process their claims, but the government has decoupled protection from citizenship. The new message is, we may grant you refuge, we may allow you to stay, but you will never become one of us. You will never be British. This is a seismic shift. It creates a potential two-tier system of residency: those who can become citizens and those who are destined to remain permanent outsiders, forever defined by the desperation of their arrival. For these two groups, the dream of citizenship is officially over. Okay, the next two groups are perhaps the most shocking, because these are people who were playing by the rules. They came to the UK legally on visas that explicitly promised them a pathway to a permanent future. But in 2025, they discovered that the finish line they were running towards was a mirage. I'm talking about Hong Kong British national overseas visa holders and, crucially, most work visa holder. Let's break this down because it's the most significant proposed change of all. For years, the standard journey to settlement in the UK was a 5-year path. You get a work visa, you live and work here for 5 years, you apply for indefinite leave to remain. Once you have ILR, you can then apply for citizenship. Simple. Predictable. In May 2025, a government white paper dropped a bombshell. A proposal to double the qualifying period for ILR from 5 years to 10 years. Let's start with most work visa holders. Imagine you're a skilled engineer, a doctor, a software developer. You were recruited from abroad to fill a skills gap in the UK economy. You moved your family, put your children in British schools, bought a home, paid your taxes. You did everything right, with the clear expectation that in 5 years you would have the security of permanent residency. Now, the government is proposing to tell you, sorry, you need to wait another 5 years. That's a decade of uncertainty. A decade of visa renewals, of paying exorbitant fees, of living with the constant, low-level anxiety that your right to remain could be revoked. It makes long-term planning impossible. It turns skilled workers from future citizens into long-term temporary residents. For many, this will be a deal-breaker. The promise has been broken. And this brings us to the final group, Hong Kong British national overseas visa holders. This is perhaps the most politically charged change of all. The B&O visa was created in 2021 as a direct response to the crackdown on freedoms in Hong Kong. It was presented to the world as a pathway to citizenship, a lifeline offered by the UK to honour its historical commitment to the people of Hong Kong. That pathway was explicitly stated to be 5 years. Now, the proposal to extend the ILR route to 10 years threatens to pull the rug out from under the feet of hundreds of thousands of people. Campaigners are furious, arguing that this is a betrayal. People left their homes, their careers and their families in Hong Kong based on a 5-year promise from the British government. To change the rules halfway through the game is seen not just as a policy shift, but as a profound breach of faith. While the government says it wants to make settlement earned and not an automatic right, for these two groups, it feels like a punishment. It's a 10-year trap that delays their ability to get ILR and therefore delays their ability to even apply for citizenship by a whole decade. While the door isn't permanently bolted like it is for the other groups, it has been pushed so far into the future that for many, the dream of becoming a British citizen in a timely manner has effectively died. So there you have it. Visitors, blocked to be entrance. Those who entered illegally or by dangerous means, barred for life by a new moral code. And for skilled workers and Hong Kongers who play by the rules, a journey that has been doubled in length, a promise deferred, and for many, a dream denied. The United Kingdom of 2025 is sending a new, unambiguous message to the world. It's a message that settlement is a rare privilege, not an expectation. That the path to becoming British is narrower, steeper, and for many, completely impassable. Whether you see this as a necessary measure to control borders or a heartbreaking betrayal of trust depends on your perspective. But what is undeniable is that the landscape has changed forever. The drawbridge to Fortress Britain is being pulled up. A crucial final note, the proposed 10-year route to settlement is, as of right now, a proposal from a government white paper. It is not yet law and is subject to consultation and change. However, the changes to the good character rules are already in effect. Immigration law is complex and changes fast. This video is for informational purposes only and is not legal advice. Please seek guidance from a qualified immigration lawyer for your specific situation. There is a story being told every single day on the news. A story of a nation under siege from its borders. But while every camera points towards the sea, the government is waging a secret, far more effective war on a different front. This is the unimaginable twist of 2025. While the public is told the problem is illegal immigration, the real crackdown, the real punishment, is being dealt out to you. The legal migrant. The person who followed every rule, paid every fee, and is now standing at the finish line of a 5 or 10-year marathon, only to be banned. You are being banned for a single traffic fine from years ago. You are being banned for a political opinion you posted on social media. You are being banned because of who your friends are. You are being banned for a gift from your own parents. And you are being banned for a single undocumented day out of the country. These are the 5 new de facto bans on UK citizenship and ILR, and they are designed to make you fail. Before we expose these traps, you need to understand that this information is your only shield. Please, give this video a thumbs up. It is a signal to the algorithm that this is an urgent alert that every legal migrant in the UK needs to see. Share it with your family and in your community groups. To my subscribers, thank you for trusting me to uncover the truth. If you are new and your entire future in this country is on the line, subscribe now. The system is no longer just about meeting the requirements, it's about surviving the hunt. Let's first address the Great Deception. The government needs to show its voters that it is being tough on immigration. The problem is, dealing with complex international asylum issues is incredibly difficult and politically messy. But you, the legal migrant, are the complete opposite. You are the perfect target. The government has a file on you that is inches thick. They have your address, your employer, your salary, your travel history, your fingerprints. You are documented, registered, and completely visible. Therefore, when the political pressure mounts, the easiest way to get a win and generate a headline about reducing net migration is not to solve the hard problem, but to turn on the easy target. It's to find a new reason to refuse the thousands of ILR and citizenship applications that are sitting right there on their desks. Your application is no longer a formality, it is a political football. The first and most widespread ban is the weaponization of the good character requirement. This has always been a vague part of the application, but in 2025 it has become a time bomb. Caseworkers are now being instructed to perform a full forensic audit of your entire life in the UK, looking for any transgression, no matter how minor, to justify a refusal. We are talking about things you have long forgotten. A fixed penalty notice for littering. A single late tax return that you paid off years ago. A heated argument with a neighbour that resulted in a complaint, but no police action. Even a series of unpaid parking tickets can be bundled together and presented as evidence of a pattern of disregard for UK law. They are building a case against you using the scraps of a normal, imperfect life. Your 10 years of paying taxes and contributing to society are irrelevant. That one mistake, that one moment of poor judgment is now the only thing that matters. It is a character assassination designed to deny you your future. The second ban is the social media minefield. Your digital footprint is now considered fair game, and it is being actively monitored. When you apply for ILR or citizenship, do not assume your file only contains your official documents. It can now include a printout of your social media history. What are they looking for? Anything that can be twisted to suggest you are not fully integrated or that you hold views contrary to British values. A joke that was taken the wrong way. A passionate political post criticizing a government policy. Sharing an article from a controversial news source. Even being a member of a Facebook group that has other members who have posted extremist content can be used to taint you. You are being held responsible not just for what you say, but for what people in your digital vicinity say. This is a terrifying new frontier. Your freedom of speech is being used as a test of your loyalty, and failing that test can lead to a direct ban on your settlement. The third ban is what I call the financial autopsy. You know you need to prove you can support yourself. But now, it's not about how much money you have, but a forensic, and often impossible, examination of where every single penny came from. This is particularly dangerous for applicants who have received gifts from family to help with the extortionate application fees. Let's say your parents in your home country transfer you £3,000. The Home Office may now demand a full, translated and notarized history of how your parents earned that money. They will want to see your parents' bank statements, their employment contracts, their tax records, to prove the money is not the proceeds of crime. It is an intrusive, humiliating process that treats your family like criminals. If you cannot produce this mountain of evidence to their exact satisfaction, the money is deemed of unproven origin, your application is refused, and you are flagged as a potential money launderer. It is a trap designed to punish people for having a supportive family. The fourth ban is the most dystopian of all, the guilt by association doctrine. The Home Office is now looking at your network. Who you associate with can, and will, be used against you. This goes far beyond criminal gangs. Let's say you once shared a house with someone who later overstayed their visa. Or you worked at a company where another employee was found to have used a fake document. Caseworkers can argue that you were in proximity to a breach of immigration law and that this reflects poorly on your own character. They can question why you didn't report the person. It creates a climate of paranoia and fear, forcing migrants to be suspicious of each other. You are being made responsible for the actions of your friends, your housemates, and your colleagues. This is a divide and conquer strategy. By making everyone a potential liability, it shatters the community support networks that are so vital for navigating life in a new country. The fifth and final ban is the 181st day catastrophe. Everyone knows about the rule against being absent from the UK for more than 180 days in any rolling 12-month period. The ban isn't the rule itself, it's the brutal, unforgiving and deliberate lack of context in its application. In the past, there was some discretion for compelling circumstances. That discretion is vanishing. A family emergency, a medical crisis back home, or even a flight cancelled due to an airline strike that pushes you to 181 days of absence can now trigger an automatic refusal. The burden of proof is on you to provide an impossible level of evidence. It's not enough to have a doctor's note they might want to see the hospital admission records of your sick relative. It's not enough to share a cancelled flight they will argue you should have booked an earlier one. They are removing all humanity from the equation. A single day, a single unforeseen event, can erase 5 or 10 years of your life in the UK. It is the ultimate technicality, and it is being used to crush the dreams of thousands. These 5 bans are the new reality. They are the weapons being used in the government's quiet war on legal migrants. While the headlines scream about boats, you are the one being sunk by paperwork, by technicalities, and by a system that has decided you are a far easier enemy to defeat. Your journey is no longer about compliance, it is about survival. Thank you for watching. The first step in surviving this war is knowing the battlefield. Please share this knowledge. Discuss these points. If you have been a victim of one of these traps, share your story in the comments below. By bringing these tactics into the light, we build our collective defense. Stay vigilant.
You've followed the rules, paid your fees and contributed to this country. The final goals on that journey? Indefinite leave to remain, or ILR, and for many, the ultimate prize, a British passport. But what if I told you that in 2025, the goalposts are shifting? What if the path you thought you were on is changing with new, unexpected hurdles? And what if, even after you've reached the pinnacle and become a British citizen, that status isn't as permanent as you believe? It's a shocking thought, but it's the reality we need to talk about today. The UK's immigration landscape is undergoing some of its most significant changes in years, and for some, this means the dream of ILR and British citizenship might be slipping away. Worse yet, some who already hold that precious blue passport could find themselves at risk of losing it. Please welcome to our in-depth look at no more ILR and British citizenship for these people in 2025 and the chilling reality of losing your British citizenship. Yes, it can happen. Stay with me because the information in this video is crucial for anyone on a UK visa applying for settlement or who is already a naturalised citizen. Let's start with indefinite leave to remain, or ILR. For years, the magic number has been 5. Most people on work routes like the skilled worker visa or on family visas knew that after 5 years of continuous residence, they could apply for permanent settlement. It was a clear, predictable timeline. However, a government white paper published in May 2025 has laid out plans for a radical shake-up. The proposal? To increase the standard qualifying period for ILR from 5 years to a staggering 10 years for most visa holders. Let that sink in. A decade. That means double the time living with the restrictions of a visa, double the time needing a sponsor for many, and double the time before you can truly call the UK your permanent home. This change is intended to make settlement a more earned privilege, based on a longer-term contribution to the UK's economy and society. So, who is affected? The proposal suggests this new 10-year default will apply to most work-based migration routes. There are some crucial exceptions. The government has indicated that partners of British citizens on family visas will likely continue to qualify for settlement after 5 years, as will victims of domestic abuse. People with rights under the EU settlement scheme are also protected by the 5-year rule under the UK-EU withdrawal agreement. But for many others, the path just got a lot longer. And it's not just about waiting. A longer qualifying period means more time for things to go wrong, and the reasons for ILR refusal remain as strict as ever. What trips people up? It's often the same pitfalls. Excessive absences. You can't have spent more than 180 days outside the UK in any 12-month period during your qualifying years. With a 10-year route, that's a long time to keep track of every single trip. Tax discrepancies. The Home Office and HMRC share data. Any inconsistencies between the income declared on your visa applications and your tax records can be seen as deception and lead to a refusal. Application errors. A simple mistake on a form, missing a document, or using the wrong form can result in a flat-out refusal. Criminality. Any criminal conviction, even seemingly minor ones, must be declared. Depending on the sentence, it can lead to an automatic refusal or require a long period to have passed before you can be considered. Immigration history. Overstaying a previous visa or any breach of immigration rules, even if it was years ago, can come back to haunt your application. So, the message is clear. The journey to ILR is set to become a marathon, not a sprint, and every step of that 10-year journey will be under scrutiny. Now, let's talk about the final step. British citizenship. For those who secure ILR, citizenship is the culmination of their journey. But here too, a major change in 2025 is set to block the path for a significant group of people. The key lies in the good character requirement. This has always been a part of the application, looking at things like your criminal record and financial soundness. But on February 10th, 2025, the Home Office updated its guidance with a rule that is both controversial and far-reaching. The new guidance states that anyone who applies for citizenship from that date, who has ever entered the UK illegally, will normally be refused. This includes arriving without the required entry clearance or making what the Home Office defines as a dangerous journey, such as crossing the channel in a small boat or being concealed in a vehicle. What's truly seismic about this change is that it removes the previous 10-year rule. Before this, an illegal entry that occurred more than 10 years ago would often be disregarded. Now, it doesn't matter how long ago it happened. It could be 15, 20 years. It doesn't matter if you have since been granted refugee status, built a life, raised a family, and been a model resident. The very method of your arrival decades earlier could now be used to deny you citizenship. This will disproportionately affect refugees and asylum seekers, many of whom had no choice but to use irregular routes to find safety in the UK. Critics argue this new rule effectively creates a two-tier system and penalises people for circumstances often beyond their control, potentially violating international conventions on refugees. So, if your history includes an entry that the Home Office deems illegal, your path to a British passport, as of 2025, has become incredibly difficult, if not impossible. This is the part of the video that might be the most shocking. You've done it. You've navigated the visa system. You've passed the life in the UK test. You've pledged your allegiance. You hold a British passport. You are a British citizen. Surely that can't be taken away? Wrong. It can, and you need to know how. The power to strip someone of their citizenship is formally known as deprivation, and it's enshrined in Section 40 of the British Nationality Act 1981. It happens for two primary reasons. First, fraud, false representation or concealment of a material fact. This is the most common reason. If it's discovered that you lied or hid crucial information during your citizenship or even any previous immigration application, your citizenship can be revoked. This could be anything from using a false identity, hiding a criminal record, or not disclosing information that would have led to your application being refused. The key is that the deception must have influenced the decision to grant you citizenship. Second, conducive to the public good. This is a much broader and more serious category. The Home Secretary can revoke your citizenship if they believe it is in the public interest to do so. This is typically used in cases involving national security. Examples include terrorism, including encouraging or assisting others, espionage, or working for a hostile state, serious and organized crime, war crimes, or other forms of unacceptable behavior. Now, a critical question arises: can the UK government make you stateless, leave you with no citizenship at all? Under both British and international law, the government generally cannot deprive you of your only citizenship. However, the Nationality and Borders Act 2022 created more aggressive powers. For naturalised citizens, meaning you weren't born British, the government can now proceed with deprivation, even if it makes you stateless, provided your actions have been seriously prejudicial to the UK's vital interests. Furthermore, the Act also introduced the power for the Home Office to revoke citizenship without giving you prior notice in certain situations, for example, if it's deemed necessary for national security, or to prevent you from preempting the order. And a new bill for 2025 proposes that even if you win an appeal against the decision, your citizenship might not be restored immediately if the government decides to challenge that appeal. In 2010 and 2023, over 1,000 people were stripped of their citizenship for these reasons. It is not a hypothetical threat, it is a real power that is actively being used. The landscape of UK immigration is clearly getting tougher. The path to settlement is potentially becoming twice as long for many, and the criteria for who is of good character for citizenship have been narrowed significantly. The very permanence of citizenship itself has been shown to be conditional. So, what can you do? First, be meticulous. Every application you submit, every piece of information you provide must be flawless. Double check your dates, your documents, and your declarations. In this new environment, there is no room for error. Second, be honest. The good character test places immense value on transparency. Attempting to deceive the Home Office is one of the surest ways to not only get refused, but to potentially face a ban and have any future status revoked. Third, understand your history. In light of the new rules, be aware of how every part of your immigration journey, including your initial entry to the UK, could be assessed years down the line. Fourth, seek professional advice. The rules are complex and constantly changing. Navigating them alone is a huge gamble. Getting expert legal advice is not a luxury, it's an essential investment in your future. The dream of a life in the UK is still alive, but the journey requires more diligence, more patience, and more awareness than ever before. Don't get caught out by these new rules. Stay informed, be prepared, and protect your future. The UK Home Office has passed a new law to end British citizenship from those who show public threat to the public, especially those deemed to be performing terrorist acts. It states that
we will introduce new laws to protect children and support victims so they stop being blamed for the appalling crimes committed against them. New major police operations to pursue perpetrators and put them behind bars. New national inquiry to direct local investigations and hold institutions to account for past failures. New ethnicity data and research so we face up to the facts on exploitation and abuse.
Closure of loophole to keep terrorists and extremists out of the UK. A law has been introduced to prevent British citizenship being reinstated to people considered a national security risk following a successful initial appeal. Published by Home Office on the 19 June 2025. National security will be strengthened under a new law to prevent British citizenship being reinstated to individuals considered a risk following a successful initial appeal. The deprivation of citizenship orders effect during appeal will ensure that citizenship is not automatically reinstated after a successful appeal until all further appeals are exhausted, protecting the public from potential threats. The bill addresses a gap in the law identified by the Supreme Court, where it confirmed people automatically regain their British citizenship if their initial appeal is successful, even before further appeals have been determined. This could mean individuals who the government still considers a risk to the UK's national security can either be released from immigration detention or return to the UK whilst further appeals are still possible or are ongoing. This change will also prevent a person from having British citizenship reinstated and then renouncing any other nationalities. This would mean any future decision to deprive their citizenship following a successful further appeal could not be made, as it would unlawfully render them stateless, meaning they could also not be deported from the UK or prevented from returning if they were already overseas. Security Minister Dan Jarvis said, "Protecting our national security and keeping the British public safe is the first duty of this government and the foundation of our plan for change. The power to deprive someone of their British citizenship is an essential tool and helps protect us from some of the most dangerous people. We must close this gap in the law and prevent British citizenship being reinstated to individuals until all appeals have been determined. This is the right thing to do if we believe someone is a threat to our national security, and it will make Britain safer." Deprivation decisions on conducive to the public good grounds are taken only in the most serious cases by the Home Secretary, where it is in the public interest to do so because of the individual's conduct or the threat they pose to the UK. The change in the law follows the similar approach taken in asylum and human rights appeals cases, where asylum is not granted to a person appealing a rejection until all further appeals, up to the Court of Appeal, have been determined. This narrowly focused bill, consisting of 2 clauses, makes no change to a person's existing right to appeal any decision to remove their British citizenship, and doesn't widen the reasons for which a person could be deprived of their citizenship.
Are you a British citizen, or do you already have your indefinite leave to remain and about to become a British citizen? Or has your UK citizenship been revoked or withdrawn by the UK government? If so, then this video is for you. In this video, we are going to take a look at the reasons why the UK government is depriving or withdrawing people's citizenships in 2025. So if you've not already, please subscribe to our channel and ring the bell for upcoming updates. Now, let's begin. In the 21st century, there has been a revived use of government powers to deprive people of their British citizenship and withhold UK passports, particularly as a counter-terrorism measure. The Home Secretary has the power to take away a person's British citizenship if they consider it conducive to the public good, or if the person obtained their citizenship by fraud. The power of citizenship deprivation is in Section 40 of the British Nationality Act 1981. Citizenship deprivation happens for national security reasons, or in cases of fraud. Depriving someone of their British citizenship for the public good is generally used in the context of national security or counter-terrorism. The aim is to prevent a person who poses a threat to the United Kingdom from returning to the country, which they would otherwise have a right to do as a British citizen. For people who have naturalised as British, citizenship deprivation is permitted even if it would leave them stateless, that is, without the citizenship of any country. Someone who was born British and has no other nationality cannot be deprived of their citizenship in any circumstances. People must usually be given written notice and have a right of appeal. The Home Secretary is usually required to give the person written notice. Notice can be withheld in certain circumstances, such as where it is considered reasonably necessary in the interests of national security. There is a right of appeal against citizenship deprivation. Appeals take place at the first-tier tribunal, or, in national security terrorism cases, the Special Immigration Appeals Commission, SIAC. In SIAC appeals, sensitive evidence may be withheld from the appellant and their lawyer, and a special advocate appointed to represent their interests instead. Over 1,000 citizenship deprivation orders were made from 2010 to 2020. There have been at least 858 deprivation orders for fraud and 222 orders for the public good since 2010. The exact number of successful appeals against these orders is not known. Commentators examining known public good cases have suggested that many of those affected are Muslims with South Asian, Middle Eastern, or North African birth or ancestry, some born in the UK. By contrast, most fraud cases involve naturalised Albanians. Deprivation used to be allowed only for naturalised citizens. Deprivation of citizenship for fraud was introduced over 100 years ago by legislation passed in 1914. A power to deprive citizenship for certain types of misconduct, including if a naturalised citizen had proven disaffected or disloyal, was added shortly before the end of the First World War. Until 2003, however, deprivation was only possible for naturalised citizens. The Nationality, Immigration and Asylum Act 2002 extended citizenship deprivation to British-born dual nationals for the first time. This was possible if they had done something seriously prejudicial to the UK's vital interests. But the test was later changed to conducive to the public good. British citizens can also be refused a passport or have their passport withdrawn. British passports are issued at the discretion of the Home Secretary under the Royal Prerogative, an executive power which does not require legislation. They can be withdrawn or withheld using the same discretionary power. Withdrawal of passports is not the same as withdrawing citizenship. Someone whose passport is withdrawn remains a British citizen, but their overseas travel is restricted. Home Office policy states this will be done sparingly, such as where the person intends to travel abroad to engage in terrorism. There is no right of appeal against having a passport withdrawn, but the person can ask for an internal review by the government or apply for judicial review by a judge. From 2013 to 2023, there were 97 cases of passport withdrawal for national security reasons, according to the Home Office. The full document about this can be found on the UK Parliament website. You can check it out, download and read for further information. The United Kingdom's immigration landscape is continually adapting, and 2025 has seen significant proposals and changes impacting those seeking indefinite leave to remain, ILR, also known as settlement or permanent residency, and ultimately British citizenship. Aspiring long-term residents and future citizens must remain acutely aware of these evolving requirements, particularly following the government's May 2025 Immigration White Paper, Restoring Control over the Immigration System. While not all proposals are immediately enacted into law, they signal a clear direction towards stricter criteria and a longer path for many. The shifting sands of indefinite leave to remain, ILR. Traditionally, a common route to ILR involved completing 5 continuous years of lawful residence in the UK on a qualifying visa. This established pathway, applicable to many work, family, and business visa categories, has been a cornerstone of the settlement system. However, 2025 ushers in proposals that significantly alter this standard. The most notable proposed change is the extension of the standard qualifying period for ILR from 5 years to 10 years for many points-based system migrants and their dependents. This change, while not yet fully implemented and subject to further consultation, aims to create an earned settlement model, suggesting that a shorter pathway than 10 years may be available for individuals who have made points-based contributions to the UK economy and society. The precise definition of these contributions is yet to be fully determined, but it indicates a move towards rewarding specific economic and societal engagement. This shift has understandably generated considerable concern among those already in the UK on 5-year routes, as it remains unclear whether these new rules will apply retrospectively or only to new arrivals. Despite these proposed extensions, certain categories are expected to retain the 5-year ILR route. Partners of British citizens, for instance, are explicitly mentioned as continuing to qualify for settlement after 5 years, provided they meet all other criteria. Victims of domestic abuse are also exempt from these longer waiting periods. Furthermore, individuals with post-Brexit residence rights under the EU settlement scheme continue to hold the right to permanent residence after 5 years, as enshrined in the UK-EU withdrawal agreement. Beyond the length of residence, the fundamental requirements for ILR remain largely consistent. Applicants must demonstrate continuous lawful residence, with strict limits on absences from the UK. Typically, this means not exceeding 180 days of absence in any 12-month period during the qualifying time. Exceptional circumstances, such as being stranded due to natural disasters, illness, or conflict, may allow for discretion from the Home Office. But these are assessed on a case-by-case basis and require comprehensive evidence. A crucial component of any ILR application is proving knowledge of English and life in the UK. This generally involves passing the Life in the UK test, a computer-based multiple-choice examination on British history, culture, and society, and demonstrating English language proficiency to a specified level, usually through an approved test or a relevant academic qualification. There are some exemptions to the English language requirement, particularly for nationals of certain English-speaking countries. Financial stability and a history of compliance with immigration rules are also paramount. Applicants must demonstrate they are not a burden on public funds and have adhered to the conditions of their previous visas. Any criminal convictions, even minor ones, or breaches of immigration law can significantly jeopardize an ILR application, as they directly impact the good character assessment. The application process itself requires meticulous documentation, including proof of continuous residence, employment records, housing details, and evidence of meeting all visa-specific conditions. The Home Office assesses each application rigorously, emphasising the applicant's integration into British economic and cultural life. The path to British citizenship. Heightened scrutiny. Once ILR is granted, individuals can typically apply for British citizenship by naturalisation after a further 12 months, subject to meeting additional criteria. For those married to or in a civil partnership with a British citizen, this 12-month waiting period after obtaining ILR is often waived, allowing them to apply for citizenship sooner, provided they have met a 3-year residency requirement. However, 2025 has also seen significant alterations to the good character guidance for citizenship applications, which came into effect on February 10, 2025. These changes represent a much stricter approach, particularly for individuals who entered the UK irregularly or through dangerous routes. Under the updated guidance, anyone applying for citizenship from February 10, 2025, who previously entered the UK illegally will normally be refused, regardless of how long ago this entry occurred. Illegal entry is broadly defined to include any breach of immigration laws, such as entering without permission or through deception. Similarly, individuals who arrived without required valid entry clearance, having made a dangerous journey, which includes, but is not limited to, travel by small boat or concealed in a vehicle, will also normally face refusal. This marks a significant departure from previous policy, where irregular entry might have been disregarded after a period of 10 years, especially if the individual had subsequently been granted ILR. While the guidance states normally be refused, implying some room for discretion, the presumption is now firmly against granting citizenship in such cases. The Home Office has indicated that compelling, mitigating circumstances may lead to an exceptional grant, with children who made dangerous journeys while under 18 being considered sympathetically. However, the specific factors that would constitute such circumstances remain largely undefined, creating considerable uncertainty for many who have built lives in the UK after arriving through irregular means, including many refugees who have since been granted protection. Aside from these recent changes to the good character requirement, the standard criteria for naturalisation remain in force. Applicants must be over 18 years old, possess a clear intention to continue living in the UK, and meet residency requirements. For most applicants, this entails proving lawful residence in the UK for at least 5 years, or 3 years if married to a British citizen, with strict limits on absences. The absence limits are generally no more than 450 days out of the UK in the 5-year period, or 270 days in 3 years for spouses of British citizens, and crucially, no more than 90 days in the final 12 months before applying. The Life in the UK test and English language proficiency requirements, if not already met for ILR, must be fulfilled. The English language requirement for skilled workers and other work immigration categories has seen an increase from B1 to B2 of the Common European Framework for Reference for Languages, CEFR. And there are new English language requirements for adult dependents on initial applications and extensions. The good character assessment goes beyond immigration history to encompass criminal records, financial stability, and overall compliance with UK laws. Any past criminal convictions, even if spent, or issues with financial integrity like bankruptcy, must be declared and can impact the outcome of the